Hello everyone. Welcome again to online session of Manu Law Classes. I'm Dinesh Kumar and I'm former Assistant Professor of Law at Campus Law Center Law Faculty at University. And presently I'm working as an academic head of Manu Law Classes. So dear students, in today's session I will discuss with you one of the landmark judgment and the latest judgment of Hon'ble Supreme Court in the case of Neil, Aurelio, Nunes and others versus Union of India and others 2022. This judgment was delivered by Hon'ble Supreme Court on 20th January 2022. But before moving to the main discussion part, there is an important announcement for all of you. Admissions are open at Manu Law Classes for the upcoming batch of 2022 and 2023, including the 1-year course and 2-year course program and crash course as well. All of you may get yourself enrolled with us for getting the best result. And for more information, you can dial the given number on screen, that is 9971 444 054. Dear students, the date of CLAT examination 2022 is 8 May 2022 and the date of CLAT examination 2023 is 18 December 2022. So prepare yourself accordingly. Now your application form for CLAT 2022 are available on the website of NLU's consortium and the last date to fill the form is 31st March 2022. So fill your form timely and wish you all the best. So dear students, now we come to the main discussion part of the case. In this case, I will discuss with you Article 14 and 15. And this case is related to the reservation in admission in the various educational institutions. This case particularly is related to the 27% reservation of OBC in the NEET examination. So now we come to Article 14. Article 14 is the genesis of our right to equality. Right to equality has been provided from Article 14 to 18 of the Constitution of India. And Article 14 ensures the equality before law and equal protection of law. It gives the direction to the state that state shall not deny to any person equality before law and equal protection of laws. Equality before law means all the citizens of India or all the person who are living within the territory of India will be considered equally before the law. Means there will be rule of law. Means if a person is very high in position and that person commits any violation of law, then that person will be treated in the same manner as a poor person will be treated if that person violates the provision of any law. Similarly, all the person within the territory of India will be entitled for the equal protection of laws. So there will not be discrimination. But this right to equality provided under Article 14 is not absolute in nature. Rather, it is subject to certain exceptions or subject to some reasonable classifications. Article 15 is one of them. Now we come to Article 15. Article 15 clause 1 provides that state shall not discriminate amongst the citizens of India any on the ground of religion, race, caste, sex, place of birth. So there are 5 grounds and it is the direction for a state that state will not discriminate with any citizen of India on these 5 grounds. Now, Article 15 clause 5 that was added to the Constitution of India by 93rd Constitutional Amendment Act 2005 provides that nothing in this article means Article 15 clause 5 or in Article 19 clause 1 subclause G shall prevent the state from making any special provision for the advancement of socially and educationally backward classes of citizens or for the advancement of SC and STs. with respect to the admission in the various educational institution, including the private education institution as well as the government education institution, but not including the minority educational institution under Article 30 Clause 1 of the Constitution of India. तो बेसिकली आर्टिकल 15 क्लॉज 5 ये कहता है कि स्टेट सोशली एंड एजुकेशनली बैकवर्ड क्लासेस ऑफ पर्सन के लिए, एससी और एसटी के लिए एजुकेशनल इंस्टीट्यूशन में रिजर्वेशन की व्यवस्था कर सकता है। एंड ये जो एजुकेशनल इंस्टीट्यूशन है, these educational institution may be government educational institution as well as private educational institution, but this reservation in admission cannot be provided by the government in the minority educational institution, जो कि article 30 clause 1 में establish किए जाते हैं। So this is the special right of the minority people. I'm not going into the detail of that. When this constitutional amendment was passed by the parliament, simultaneously one more act, that is Central Education Institution Reservation in Admission Act 2006 was also passed by the parliament. The constitutional validity of both these legislation was challenged before Hon'ble Supreme Court in the case of Ashok Kumar Thakur versus Union of India in 2007. The constitutional validity of these legislation was challenged on the ground that these are against right to equality as provided under Article 14 of the Constitution of India. But Hon'ble Supreme Court in this case held that these both legislation, means the 93rd Constitutional Amendment as well as the Central Education Institution Reservation in Admission Act 2006, both are constitutionally valid, and state has right to provide this kind of special arrangement for the admission in various education institutions to the candidates belonging to the OBC, SC and STs. Now what happened after the decision of this case? Tamil Nadu backward classes, scheduled caste and scheduled tribe reservation of seats in education institution was enacted, means this act was enacted by the Tamil Nadu legislature, and this provides 50% reservation to OBC in the state-run medical institutions. Now, DMK, who is one of the petitioner in this case, also demanded that this kind of reservation, means the 27% reservation, should also be provided in the all India quota for the purpose of admission in the NEET course. NEET is a course which provide the entrance test for the admission in the BDS and the MBBS courses. Now the constitutional validity of this 27% reservation for OBC in all India quota of NEET examination was challenged in this case. The main issue before Hon'ble Supreme Court in this case was that whether this 27% reservation for OBC in all India quota of NEET examination is constitutionally valid or not. So Hon'ble Supreme Court, after referring to the various decisions like the decision of Ashok Kumar Thakur and Balaji etc., came to the conclusion that this reservation is constitutionally valid. Why this reservation is constitutionally valid? Because it is necessary to ensure the equality in the society. And Hon'ble Supreme Court in this case held that Article 15 Clause 4 and 15 Clause 5, which specifically provide reservation in the admission, both are constitutionally valid, and these two articles are not the exception of Article 15 Clause 1. Rather, these are the extension of right to equality as provided under Article 15 Clause 1. So, Hon'ble Supreme Court ने इस केस में ये कहा कि Article 15 Clause 4 और Article 15 Clause 5 Constitution of India Article 15 Clause 1 के एक्सेप्शन नहीं है, बल्कि ये उसका एक एक्सटेंशन है, जो कि राइट टू इक्वलिटी को एंश्योर करता है। इस केस में ऑनरेबल सुप्रीम कोर्ट ने यह भी कहा कि इक्वलिटी मस्ट बी अमंग इक्वल्स और मींस इक्वल मस्ट बी ट्रीटेड इक्वल्स। इसका मतलब यह है कि अगर कोई पर्सन सिमिलर सर्कमस्टेंसेस में है, then those persons should be treated as equal. But if the persons are situated in the different circumstances, then those persons should not be treated as equal. So that's all for today, my dear students. I will come again with the next topic or with the next latest judgment. Till then, thank you very much. Goodbye. Please take care of yourself. Follow the COVID guideline.